So let's see, we've got about 40 minutes left, and I've got some hotline issues to go through, and I'm going to talk to you a little bit about seller financing. So seller financing in New Mexico can come in various forms: mortgages, deeds of trust, real estate contracts. There's also third-party lenders. So I know that a lot of, we all think of going out to a lender, a bank, to get financing, but there are private lenders that make loans as well. But there are some restrictions on that. So I'm going to talk to you about it. So what is the difference between these various ways of providing seller financing? So there's a couple of key differences between real estate contracts and mortgages and deeds of trust. And they really fall into two main categories: title and foreclosure. So in the title category, real estate contracts, when you enter into a real estate contract, equitable interest transfers to the buyer immediately. And then legal title is transferred later on in the form of a deed to the buyer when they fulfill the terms of the real estate contract. But for all intent and purposes under New Mexico law, the buyer is the owner of the property on a real estate contract, even though the legal deed the deed has not been conveyed until they've fulfilled the obligations of the contract. Under mortgages, the deed is conveyed and both, so that's legal interest, and then equitable interest as well at the time they enter into the mortgage. And in deed of trust, it can be handled one of two ways. Either the deed of trust, under a deed of trust, either the trustee can hold the deed, which is then conveyed to the buyer when they fulfill the terms of the note, or it can be conveyed directly like a mortgage is, where the legal and equitable title is conveyed at the time that they enter into the deed of trust. Because mortgages and deeds of trust require the buyer to sign a promissory note. They promise to pay the seller an amount of money. And then the way that the seller kind of protects their interest is securitize that interest through a security instrument, and it's either a mortgage or a deed of trust, and they secure that to the house, right? So that they can protect the note that the buyer signs saying that they're going to repay the money. So the other difference, like I said, is in the foreclosure arena. Real estate contracts can be non-judicially foreclosed, which means you don't have to go to court. And so that's a much faster process. That can happen in 30 to 60 days under a real estate contract. Under a mortgage, you're going to have to go through the judicial foreclosure process, which is dictated by a statute. It can take 6 to 18 months. If the buyer goes out and gets an attorney and they're a good attorney, they can drag that out for even longer than 18 months. Deeds of trust are thought to be, and years ago when they kind of did an overhaul of the Deed of Trust Act, it was a way to kind of avoid judicial foreclosure and have a trustee sale instead, where the trustee actually sells the property. That could take about 7+ months to do. But there's another act in New Mexico which says that if it's a residential loan, it cannot be 1 to 4 dwellings. It cannot not be non-judicially foreclosed under the Deed of Trust Act. So whether you have a deed of trust or a mortgage, if you're dealing with a residential property, 1 to 4 dwellings, you're going to have to go through the judicial foreclosure process. Commercial properties can still be sold under the Deed of Trust Act through a trustee sale, which is a little bit faster, like I said. There are some restrictions on seller financing in New Mexico. They came out of the Dodd-Frank Act. They were amendments to the Truth in Lending Act. But they don't apply to all of these types of property that you see on the screen before you: vacant land and owner-occupied rental properties and land brought primarily for agricultural purposes. So none of the restrictions that apply to seller financing apply to any of the things that you see right here on your screen. And we have an information sheet in our library that talks about the restrictions under the under Truth in Lending Act for seller financing. So what will this apply to? Well, you'll notice what's not on this screen, which is not on the exclusion screen, are residential properties where the buyer is going to move into the property. So you see number 2 is purchase of properties acquired strictly for business purposes. So such as commercial and investment properties that will not be owner occupied. So you got somebody who's going to purchase a property on a seller financing instrument and they're going to rent it out, right? It's investment property. They're not going to be living in it. It would fall under an exception. But if you have a buyer who's going to purchase a residential property and move into it, then it's going to fall under these restrictions, okay? But there's some exceptions to the restrictions. All right. There's a 1 in 12 exclusion and a 3 in 12 exclusion. The 1 in 12 exclusion means that the seller can do one of these transactions in a 12-month period. Okay. They're only available to natural persons, estates, and trusts, not corporations. So in other words, if you own a piece of property in a corporation or an LLC, and you may, if you're an investor, then you can't take advantage of the 1 in 12 exclusion. And you'll see that the benefit of the 1 in 12 exclusion is that you can have a balloon payment. So you could amortize, a transaction over a 30-year period to keep those monthly payments down for the buyer, but you could have a payoff in 5 years, or you could have a payoff in 10 years or in 3 years, and whatever period of time you want to. So the balloon payment is a big deal, because if you can't have a balloon payment and you're having to amortize that instrument out over a 5-year period because the seller wants their money in 5 years, and obviously those buyer payments are going to be huge, right? If you're only amortizing it out over 5 years. And so balloon payments are a way to keep the payments down for the buyer and yet still get the seller paid out within a period of time if they don't want to wait 30 years to get their money back. So we really like this 1 in 12 exclusion. So sometimes, if somebody owns a piece of property in an LLC or a corporation and wants to do a seller financing instrument to sell it, they may convey that in, back into their own personal name so that they can sell it under this 1 in 12 exclusion. Again, you can have balloon payment. You can't have negative amortization. So that just means that the monthly payment that the buyer is making has to at least cover the interest on the payment, right? At least cover the interest on the payment. There are some restrictions on the interest rate, but they're not bad. Fixed or adjustable. If they're adjusting, they can't adjust any sooner than 5 years. And there's a margin to an index that you're supposed to be using that I think most people do. So, but the 1 in 12 exclusion is kind of business as usual as we think of it. The 3 in 12 exclusion is available to natural persons, estates, trusts, and corporations. So this means you can do 3 of these type transactions in a 12-month period. So if you're a corporation, so you can't use the 1 in 12, you're going to be using the 3 in 12. Or let's say you've already done your 1 in 12. Let's say you were an owner that bought a bunch of investment properties, and then after not getting paid rent for 2 years under the state's moratorium, you decide you don't want to be a rental property owner anymore. And so you're going to sell all your properties off, and you maybe want to do it through seller financing. So you get some monthly income every month from them. Maybe for tax purposes, that would be a benefit opposed to getting a big lump sum payment. And so you're selling these off on contracts or mortgages. But you have already used your 1 in your 12 exclusion, and now you're into this 3 in 12. Because even though you own it as a natural person, if you don't wait another 12 months to do the 1 in 12, you're going to be utilizing the 3 in 12. And like I said, the problem with the 3 in 12 is the fact that there are no balloon payments. So whatever the amortization is, however long, if the seller wanted to get paid in 5 years or 10 years, that's your amortization right there. And so, of course, that could really bump up a payment, right, for a buyer if you're doing it over a shorter period of time. The other thing with the 3 in 12 is that the seller has to make a good faith determination of the buyer's ability to make the required payments. So it's the same kind of stuff that the banks are typically looking at. Just how much is the monthly payment? What's the debt to income ratio? So the seller is supposed to be looking at these things to determine that the buyer can actually make the payment. So the question I get about those. Who's making sure that the seller is doing these things? Well, you have to remember that these exceptions under these 2 things are the exception to having a mortgage loan originator license. This is why they say if you're a seller selling under these conditions, you don't have to have a mortgage loan originator license. But if you don't follow these rules and you sell, then number 1, the regulatory body, which is the financial institutions division that regulates the mortgage loan originators, could come after you and say you should have had a mortgage loan originator license to do that because you didn't follow the rules. And the other thing is that if the buyer should default on the seller financing instrument and they get an attorney that knows what they're doing, they're going to bring out the fact that the seller didn't do things in compliance with the law, and that could jeopardize the seller's ability to exercise their rights in the event of a default, which may be taking back the property, foreclosing on the mortgage, whatever the case may be. So that's the importance of following these rules. It's otherwise it's not like people are just walking around looking to make sure that this has happened, but either the MLO licensing folks might see it, or it's going to come out if there's a default. So the other thing I just mentioned briefly, because I know it doesn't come up all that often, is private third-party lenders and more than 3 in 12 need MLO licensing. And the private third-party lenders only need MLO licensing in the event that they're loaning money for a residential property, because that's what's required in New Mexico. If they're loaning money for somebody to buy a house, my dad wants to loan me money to pay cash for a house. And they're going to take out a mortgage or a deed of trust to securitize that loan. They're going to have a mortgage loan originator or use a mortgage loan originator. Okay. And then if you get over 3 in a 12-month period, again, you're talking about MLO licensing. So let's just quickly walk through our 2402, which is our real estate contract addendum. So the first section is the seller's right to approve of a buyer's financial qualifications. We talked about how that may be required if you're doing that 3 and 12. It's not required on that 1 and 12, but you may want to. A seller may want to know that the buyer has, some resources and some income and things to make those payments. So this is where the seller would get to say, I want to see certain things and I have such a certain amount of time to approve those things. Paragraph 2 was just how to take property. So tenants in common, joint tenants. It says brokers not permitted to advise the buyer on how they should take title, but everybody I think kind of knows what tenants in common and joint tenants are. Tenants in common, I don't want to simplify this too much, but we do have a limited amount of time. The biggest difference is that if you own something in joint tenancy, then the other parties who also own it as joint tenants have right of survivorship. So in the event that you should pass away, your interest is going to automatically convey to those joint tenants, and you're not going to have to go through probate and all those kind of things. Whereas if you're a tenant in common, then you have an undivided interest in that property that you can, or a divided interest in that property, that you can convey. So you can leave that to your heirs, and then your heirs become tenants in common with the remaining people on the deed. So that's the main difference between those. But again, you guys shouldn't get into making recommendations as to how that should be that title should be taken. Paragraph 3 is your sales price, your down payment, your assumed prior obligations, and the balance due on seller. Assumed prior obligations means that the buyer is going to step into the shoes of the seller. How often does that happen anymore? It doesn't, because there's very few assumable loans still out there, right? So when we're talking about wrapping an underlying loan, we're not talking about assuming a prior obligation. So you put 0 in there unless you can if there's actually a loan where the buyer can step into the seller's shoes. The payable as follows section talks about the amortization. I was saying, how long is this going to be amortized? That's going to have a direct impact, obviously, on the monthly payments. And is there going to be a balloon payment? You want a balloon payment 5 years, 10 years? Is it going to be a full payoff, or is it going to be a lump sum payment? So maybe you have a $5,000 balloon payment due in 3 years, and then another $5,000 due in 5 more years, and then pay off in 15, the final balloon payment in 15. So that's where you're going to be able to put these payable as follows. You're going to put amortization, any balloon payments. And then there's some language at the bottom of that says, if not sooner paid pursuant to the terms of the contract, the entire balance due shall be paid within 30 years. It says that unless it's otherwise provided for, right? So if there's an earlier payoff, then that earlier payoff is going to prevail. That's going to be the payoff term. But in the event that, for example, you have an interest-only loan, interest-only loans could go on and on and on and on and never get paid off, right? Well, contracts have to have a finite date for performance, right? Where everything's going to wrap up at a certain point. So if you don't have that, you might not have a contract. So we put that default language in there just to say, if you don't otherwise provide for it, it's going to be paid off in 30 years, because we don't want to challenge. We don't want someone to say, well, we really didn't have a contract because there was really no plan for it to ever be paid off. The next section of that paragraph, you get to put the interest rate, you get to put the late charges, when and how much, and then you get to say whether it's going to be periodic or daily interest. And I don't know how many of you guys are familiar with periodic versus daily interest, but I'm going to give you a very quick overview, very, very simplistic overview, I should say, of the two. So periodic interest, let's say you have a due date of the 1st of the month. Periodic interest means that interest is going to be calculated as if that payment was made on the 1st of the month, every single month. So the buyer may make the payment early, the buyer may make the payment late, but interest is going to be calculated like it was made on the 1st of the month, every single month. Daily interest, on the other hand, is going to be looking exactly when that payment came in and calculating interest based on exactly when that payment came in. So in the event that the buyer pays early, they're going to save a little interest. And if you have a buyer who pays late, they're going to pay a little more interest, right? So that's kind of the difference between those two. And it's very important to have that conversation with your buyers and sellers, because I can't tell you how many times they're confused when they get a payment. They look at their payment statement and see how much went to interest and how much went to principal, and they didn't realize how interest was being applied. They're late on their payment and they don't understand why they didn't get more credit for principal. Well, because you were late on your payment, and more of your money went to interest this month than last, because your payment was late and you were on daily interest. So it's important for them to understand what that means. There's more, obviously, in periodic interest, you're going to see more of the payment going to, every month, the same amount going to interest, the same amount going to principal, and the percentage wise, or similar numbers. Daily is going to be, fluctuate based on when that payment came in. Prior obligations, if there are anything that's being wrapped, that's going to be listed there. So these are obligations or even assumable obligations. They're all going to be listed there. And then if any prior obligations are currently outstanding on the property, you're going to check whether they're assumed, and if they're assumed, whether they're going to be paid directly by the buyer or through the escrow company. So in other words, is the buyer going to make payments to the escrow company? The escrow company is going to pay the assumable loan, or is the buyer going to make those directly? If they're wrapped obligations, that means they're not assumed. So the seller is still on the hook for those underlying obligations, but you're going to take that real estate contract and you're going to wrap it around those prior obligations. And this is where you get to decide whether they're going to go through escrow or pay directly by seller. I am a huge fan of escrow. I always have been a huge fan of escrow. So because that way you can keep track of payments and you aren't at the mercy of the seller making the payments. Because obviously if the buyer does everything they're supposed to do and they make their payments every month, but that payment doesn't make its way to the underlying mortgage, then that will be foreclosed and the seller will be in bad shape, but they've been pocketing all the payments. So you hardly feel sorry for them, right? But the buyer's been doing everything right and they're going to lose everything. So very, very important that those payments make it through to the underlying mortgage. We talk about a due on sale clause in that form. Due on sale clause in mortgages says that in the event that any interest in the property has been conveyed by the seller, that the buyer has, the lender has the right to call the note due. It doesn't say that they will. It doesn't say they have to. It says that they have the right to. I've had a lot of experience with contracts over the years. I was great friends with Rick Tom, who owns Security Escrow, and he and I used to talk about this issue. Neither one of us have experienced an underlying mortgage holder who has called a note because it was sold on a contract or on a contract, a real estate contract. Not to say it can't happen, it certainly can, but normally when the underlying holder of a mortgage calls a note, it's because something else hasn't happened. So the payment hasn't been made, the insurance hasn't been maintained, the taxes haven't been paid. That's what causes that to happen. It's not to say that it can't happen. There was a divorce situation where there was an angry wife who, when the property was sold on the contract, kept making phone calls to the lender to tell them that the property had been sold on the contract because her husband had wanted to do it and she really didn't. And I think they did eventually, call the note. But it just doesn't happen very often. I mean, like I said, I've never had any experience with it happening. Rick, his experience that it hadn't happened except for 2 times, and it had nothing to do with the fact it was sold on a contract, but rather because other things hadn't been happening. But again, I'm not ever going to say never. It does provide that if that should happen, the buyer is going to come up with the money within 30 days and pay off that loan. There's a provision for maintaining the property, and then the parties have to agree to an insurance amount. And I get asked frequently, what should we be putting in here? Well, the first one, A1, is about the improvements on the property. What do we have to improve? How do those have to be insured? So if they should burn down, you want not less than the greater the replacement cost of the improvement or the balance due seller, right? The seller's going to want to make sure there's enough money out of those mortgage proceeds to pay off that contract. But you also can put a specific dollar amount in there as well. So you got to mark A or B. Liability insurance means if somebody comes on the property and gets hurt, then how much insurance is available? I always tell everybody, look at the type of property it is. If it's a commercial property, you're going to have a lot more traffic, a lot more likelihood that somebody's going to get hurt on the property. So if you have commercial, you're going to want a higher number. If you have residential, it might be a lower number, maybe nothing less than $500,000, but you're going to have a lower number. But what's happening on even the residential property? Is there a pool? Are there horses? Are there trampolines? Are there things that people can get hurt on? And if they do get hurt, they could get really hurt. Well, then you're probably going to want to increase that dollar amount. If it's just your normal little subdivision home, then $500,000 is probably fine. But if there's something that people could really get hurt on the property, then you're going to want to increase that. And of course, if there's flood insurance, you're going to want to provide for that. And if there's no prior obligations, then this is the only insurance that's going to exist on the property, whatever you guys put in this paragraph A. If the buyer is assuming a prior obligation, so again, they're stepping into the shoes, then they're going to maintain the insurance as required by the holder of the assumed obligation, whatever that may be. If they're wrapping a prior obligation, and this gets a little more complicated, because if they're wrapping a prior obligation, they want to maintain that insurance that's required by that underlying obligation, right? Whatever that mortgage holder is requiring. But in addition, we also recommend that the buyer maintain insurance in accordance with 6A. So 2 policies. And I know that sounds weird and counterintuitive, But the reality is that the underlying policy is for the benefit of the seller with the lender named as the loss payee. And if there should be a claim made against that policy and the insurance company, they kind of sometimes look for reasons not to pay claims. They see that the property has been transferred to the buyer, or equitable title has been on a real estate contract. They may deny that claim. And so the buyer's policy, which names the buyer as the policyholder and then the seller as the loss payee, would come into play and take care of that loss. So I encourage two policies if you're doing a wrap. I know it seems a bit wasteful, but it's really the only way, in my opinion, to guarantee that you're going to have coverage. And then taxes, the buyer's going to have the property taxed for, put in the buyer's name if the county assessor will allow it. And then how are taxes and insurance going to be paid? Are they going to be paid through a new impound account? So there's no prior obligation, but you're using an escrow company and the buyer's making payments every month with part of their principal and interest payment for taxes and insurance. And the escrow company is holding those funds until they need to be paid out to the county, until they need to be paid out to the insurance company. And so they're holding them, and you're going to have to create an impound account for that purpose. Or is there's an existing impound account? So there's an underlying obligation, and that mortgage company is already collecting for taxes and or insurance, right? In that case, what about that second policy? Do you want a new impound account for that? Or are you going to let the buyer pay for that insurance policy outside of escrow? And then C is direct payment of property taxes and insurance. Of course, it can be set up so that buyers pay for everything outside of escrow. Nothing goes through escrow. I'm not a big fan of that. Again, never have been, because what ends up happening sometimes is buyers don't pay. They don't provide proof of insurance or proof of property taxes have been paid to the seller. Next thing you know, the seller is busy and time gets away from them and they don't realize they didn't get proof of payment. And now they're several years behind on taxes. There's several, maybe no insurance on the property and something could happen and then there's no coverage. So the escrow company is making sure that those payments are being received and getting where they need to go. So again, not a fan of buyers doing that outside of escrow. If there's condo fees or insurance fees, this is where you would indicate who's going to be paying those, whether you can go through escrow or paid outside of escrow, and contact information for the HOA. The standardized contract says that in the event that a buyer, a buyer on a real estate contract wants to turn around and sell the property, standard language is that they only have to have the seller's consent if they're not going to pay off the contract. Right? If they are going to sell the property and pay off the real estate contract, you don't need any consent from the seller. But in the event that you're not going to pay off the contract, then you need consent from the seller. I have seen a few contracts that have been drafted by other attorneys that provide that you have to have consent regardless. I'm not even sure that's enforceable. But in the event you get contacted by a buyer who's bought on a contract, you probably want to take a look at the contract and just make sure that it's not one of those kind of strange contracts that I don't see a lot of, but have seen that require the seller's consent regardless. Most of the contracts, like I said, only require consent of the seller if the contract isn't being paid off. Insurance, we highly encourage insurance on real estate contracts. Very important. The title company is going to be doing a lot of things. They're going to be looking, obviously, at the liens on the property. You don't want the buyer getting into a contract, making all the payments the way they're supposed to, finding out after they pay it off that there's so many liens that pre-existed them entering into the contract that they will never own the property. There's no clear title to be had. And maybe the seller's gone and you're not going to get that thing cleared, right? Short of perhaps a quiet title action. So you really need to know that from the buyer's perspective. From the seller's perspective, the title company will look to see if there are any liens that the buyer has, pre-existing liens that the buyer has that may attach to the buyer's interest in the property as soon as they enter into that real estate contract. Now, the buyer could get some of those liens attaching after the fact, and there is a way to get rid of those through the default process if you are working with an attorney who knows contracts. But maybe a seller wants to know, even going into it, yeah, the buyer has a federal tax lien. The minute that buyer owns that property, that equitable interest in that property, it's going to attach. And so that might impact the seller's decision to sell to that particular buyer. The default paragraph talks about how many days that the buyer has to cure a default after the default letter goes out. So if the buyer doesn't do something they're supposed to do, then there's a default letter that goes out that tells them you have X number of days to cure that default. And if you don't do it, then the buyer can exercise their rights under the contract to either A, take back the property or sue on the balance on the contract. The default, I say that the default for the default days has always been 30 days. We've always seen that in our contract. When I redid this contract recently, which is why I'm talking about it today. I did put language in here that made it clear that that 30 days is kind of a floor, a minimum, right? You need to give the buyer at least 30 days to cure that default, but you could give them more. The parties can negotiate something more, 45 days, 60 days, that can be negotiated, but nothing less than 30, because that's going to be challenged by the courts and they're going to frown on that. They're not going to like that at all. And whether or not you want to have 13 is whether or not you want to have the contract, the whole contract filed of record, or just a memorandum. The point of filing it with the county clerk's office is to put the world on notice that the seller has sold the property, right? We don't want them turning around and selling to somebody else. We want if they try to do that, we want everybody to know that they already did that once. So whether the contract is filed or a memorandum of contract is filed, it's important that something be filed. This is where you name your escrow agent and your fees, who's going to pay the fees, who's going to escrow the contract. The escrow company is going to hold the real estate contract and the deeds. When a real estate contract is created, there are two deeds created: a general warranty deed, which conveys the buyer's interest to the seller, and a general warranty deed that conveys the seller's interest to the buyer. And the escrow company holds those, because if the buyer does everything it's supposed to do and pays it off, you don't want to have to be chasing down the seller to get a deed from them to get the legal title into the buyer's name. And in the event that the buyer defaults, the seller doesn't want to be chasing down the buyer for that same document. So that's why they're held by the escrow company and released, depending on whether there's a default or whether or not it gets paid off, they're released accordingly. So the escrow company will hold those deeds, and this is where you get to identify them. Like as I was talking about earlier with inspectors and vendors, same is true with escrow companies, guys. Do a little bit of research, and if you're making a recommendation, which I never want you to make a recommendation, of course, but if you are making a recommendation, make sure you've done a little research on the escrow company that you're using, and you feel like they do a good job. Whatever you need to look at to feel like you're making a good recommendation. Otherwise, you need to tell them to go Google it and find their own escrow company. In areas, I will also add that in areas, there are escrow companies in the state that will escrow statewide. So just because you only have one escrow company in your area doesn't necessarily mean that's the only escrow company available. So they can look outside their areas, because there are online platforms and things that are available, so that you can people can escrow at something located in a different city, that provide access to all their accounts, information, and everything online, like all the credit card companies and things do. So they can look outside the area. They don't necessarily have to be going with someone local. So again, escrow fees, and then how those fees will be divvied up to the seller. All right, so last part of this presentation, which I have about 10 minutes left, I want to talk about some hotline issues. First thing I want to talk about is mortgage fraud. Oh my goodness. We updated some forums. They've been out since last October, but this is the YouTube channel. If you didn't get to see what those look like, I encourage you guys to go there. That's the end of my presentation today. You have questions, call me on the hotline. Don't call me about the appraisal contingency stuff quite yet, because that's still being massaged a little bit. And when that form gets released, I'm going to do an update, a video that you guys can watch. And so if you still have questions after that, feel free to get in touch with me. I just wanted to introduce all of that to you and let you know it's in the works, and that we are working through that right now. Hopefully something will be out in the next week to 2 weeks on that. And that's all I have for you today. Thank you guys so much for hanging in there with me. I know I'm about 10 minutes over. That's not too bad at all. I hope you guys have a wonderful rest of the day and a wonderful weekend.